Welcome. This is American Photographic Artists, APA. This is the first of our series for the Legal Lounge with Stephen Doniger. APA's mission is to advocate, educate, and elevate the professional photographic community. We're here today to help answer some questions about hiring an attorney, which is an important part of having a photo business, whether you're trying to write a contract, review terms with a client, or, of course, if you've been infringed upon, what to do to protect your copyright, protect your intellectual property, and how to proceed. And that is a big question for so many people. We have Stephen Doniger with us today, which I am really proud to say is an important part of APA, is Stephen Doniger's work with us to help protect photographers in their rights for copyright and for a lot of legal issues that photographers deal with every day, and certainly now with artificial intelligence and NFTs and everything being thrown at photographers every which way that we never thought of before, what we can do to best protect photographers. We're going to be doing this as a regular series, the second Tuesday of every month. We will be talking about estate planning, image licensing, sub-licensing. What does that mean when you're posting your work on social media? What happens when you're photographing celebrities or street photography, things to understand to protect yourself. And really just a great way to bring the community together and talk about the issues that and challenges that face photographers. And Stephen Doniger is not only a great attorney for APA, but also for our industry. He is a California super lawyer, which I always love to say. And so he represents lots of photographers around the country. Doniger Burroughs is also based in New York, and they have locations around the country. So they represent photographers from everywhere. And I will pass it over to you, Stephen, if you want to say a little bit more about that.
Yeah, thanks so much, Juliet. It's a pleasure to be here. It's a pleasure to speak to the group again, and I'm really honored and humbled to be able to work with APA. The work you guys do is phenomenal, and I'm glad to be a part of it. So I'm looking forward to this series of webinars until artificial intelligence takes my job away from me and you start getting a computer telling you what to do with your how to protect yourselves. But until then, I've got a little bit of job security, and but this is a really great topic. I mean, today's topic is, I don't think it lands for people the way that it should. We've handled literally thousands of copyright infringement cases, settled thousands of copyright infringement cases, brought in tens of millions of dollars for artists who've been aggrieved. And we've seen companies hire attorneys that on either the plaintiff side or the defense side that don't really know what they're doing, or the financial incentives really favor the attorneys dragging out litigation longer than it should, or we'll talk about this. We'll talk about the different ways that attorneys can be retained, about like how to make sure that you've got a sort of as much uniformity of interest between the attorney and the client as possible, and just really how to get yourself set up to maximize your chances of success. And that doesn't just mean the victory on paper, but really making sure that you're getting the best result for yourself. So the first, let's just launch into it, because we've
this is what we're here to do.
So the first thing, Juliet, I saw you wrote a bunch of bullet points. I'm just going to kind of go through those because there's a lot inside of each one of them to sort of unpack. And the very first one is like, what to know about hiring an attorney, types of attorneys, et cetera. But I want to start with the first question, which is like, do you even need an attorney? Sometimes you don't. There are people who are like, oh, I have to register my copyrights, I'm going to look for an attorney. It is something that a lot of photographers do themselves. I need to have someone transfer the copyright in a work to me, or I need to transfer the work in my copyright to someone else. there's certain things like a transfer of ownership interest that really, there's no magic language. Really, all you need is just a fairly clear statement of I transfer the rights for whatever consideration. And it can just be, one or two sentences. And a lot of times you can find templates online. People, I don't want to talk myself out of work. I don't want to talk my colleagues out of work, but I also want to make sure that people aren't, retaining attorneys and paying for things that they don't need to be paying someone for. There are certain contracts where, sometimes you can find a template online that is workable, and sometimes you find a template online and it really isn't something you should be using. And having a good resource, someone that you can go to and say, hey, that you trust to say, is this going to be sufficient or not, is important. Otherwise, you may end up paying someone for something you don't really need. With that said, there are two basic types of attorneys. There's litigation attorneys and there's transactional attorneys. Transactional attorneys, as the name suggests, engage in transactions. They will set up businesses. They can incorporate for you. They can take care of registrations. They can taking care of contracts. And certainly at times they serve a very important role. You probably want to ask one of the, and we'll get to this sort of later on, like before you sign up for someone of questions to ask, but you really want to ask them, do a bit of research. And if you're looking to just incorporate your company, if you're looking to just register a trademark, you might want to ask them, what do you do or what do you offer that I can't get through, a Sundocs or a LegalZoom or one of the other companies of paralegal services that are often much less expensive. And again, this is another one of the sort of situations where you've got to ask yourself, do I need an attorney? I don't mean to cast aspersions on my transactional brethren out there, but a lot of my personal view is that, like, as a litigation attorney, I go into court, I litigate cases, I have to know the rules of civil procedure, I know the rules of evidence. There's a bunch of things that I do as a litigation attorney that most transactional attorneys could not do. What most transactional attorneys do in terms of drafting contracts or the registrations or applications, I do. So a lot of times a firm that will handle litigation, not always, but a lot of times a firm that handles litigation will be able to handle your transactional needs. A firm that's a transactional firm will not be able to handle your litigation needs. So if you're kind of looking for a one-stop shop, you probably want to start with someone that does, a bit of both, but focuses on litigation. And I say that because if they don't really focus on litigation, you probably don't want them handling litigation for you. So that's sort of the first question. In terms of, who you hire, you really want to know what they focus on. And there's questions to ask before starting the clock, and we're going to kind of get into some of those later on, but you really want to know what area of law does someone practice. If what you need is a copyright attorney, and the person that you're talking with mostly handles, probate court or bankruptcy or something, entirely different, you probably don't want them handling that case. You want to ask what their firm does, what the work, ask them about their experience. And ultimately you've got to trust your gut. You really have to like feel like there's a connection, with the attorney. And we'll talk about that, a bit more toward the end of the webinar, as we get into the questions to ask before starting the clock. But I want to move on. Like, once you find an attorney who specializes in, who handles what you do, what you need, who can take care of you, the next question is, okay, how does this attorney get paid? And there's really 4 ways. The 2 that everyone thinks about are, well, you're either paying them hourly or they're on a contingency. And we'll talk about those first. Hourly billing is obviously, hourly billing. You're gonna get a bill in periodic intervals for the time spent by the attorney, and that time is then going to be multiplied by their hourly rate, and that's what you're going to pay. When I said earlier to make sure that you're hiring an attorney that really focuses on the area that you need, it's because the hourly rate of that attorney is supposed to reflect the experience of that attorney in a particular area. In theory, if you're a first or second year attorney and you're billing at a rate of, $270 an hour, I'm going to do easy math. Let's say $250 an hour. And then you've got a senior attorney who's been doing this for 30 years and is charging $750 an hour. In theory, it takes that attorney with the 30 years a third the amount of time because of their experience to do the work as it takes the first year attorney. And so regardless of which attorney is doing the work, it should cost you the same amount. If it costs the first year attorney charging $200, second year attorney charging $250 an hour, if it takes them 3 hours, they're going to charge you $750. If it takes the senior partner 1 hour to do what they could do in 3, it's going to charge $750. The product that firm delivers to you, in theory, should have the same cost regardless of who's doing it. That's in theory. The problem, though, is that attorneys who don't specialize in a particular area of law are going to bill at their hourly rate because they've been in practice for 10 years or 12 years or 15 years. And that rate is only justified if that's really what they specialize in and what they do. If I'm billing at my hourly rate to figure out a claim for breach of fiduciary duties between an agent and the party they represent, and that's not really what I do, it's going to take me maybe a little bit faster than someone that doesn't have the same background, the same number of years of experience, because my general research skills are a little bit better, but I shouldn't be billing at that hourly rate. So when and this is something, again, we'll get into when we talk about questions to ask before starting the clock, you really want to know what is the primary area of, what percent of that attorney's practice is what you need them to do work on. How long has that been? Is it their primary area of practice? How long has it been their primary area of practice? And make sure that the hourly rate that they're charging reflects an appropriate level of expertise in that area of law. Or if they don't necessarily have that, ask about who else is at your firm. Are there junior associates? Can this be handled by junior associates? So, and there's going to be a little bit of jumping around in this discussion, but in terms of that first question of the hourly rate, I want to convey to anyone listening to this that the hourly rate, the reason why there's going to be a significant disparity in rates, and as we go through our years of practice, the rates go up, in theory, is that it should take us less time than to handle things. So the hourly rate is the first structure, and that is what the legal industry has traditionally been based on. There's also contingency fee representation. Contingency fee, as the name suggests, means that the fees, the attorney's fees are contingent or dependent on the results obtained. And often it's going to be, some attorneys just do a flat rate, some attorneys do a tiered rate. And this is another thing that you may want to consider and talk to your attorney about. Personally, I think that a tiered rate is always appropriate, because it tends to put the attorney's interests and the client's interests a bit more in line. If the client says, well, I don't want to settle at this early point because I think that the case I might get a little bit more later on, that's fine. But at certain points in that litigation, the attorney's fee for the amount of extra work, their percentage should go up a little bit to then both compensate them for the additional work, so the attorney has an interest in fighting harder as opposed to just, well, my percentage is the same no matter what, so I might as well settle earlier. And then it also creates the appropriate incentive for the client that, well, I have an incentive to settle sooner, even if it might settle for a little bit more later on, because my percentage is going to go down, as the attorney's contingency percentage, tiers up.
Is that the way a contingency tiered works? Is that the percentages changes over the length of the case?
Yeah, it can. And like, we don't have a fixed percentage. We always base it on the nature of the claim. There are some claims that are just small claims. There's a lot of like small, we have an artist advocacy program through which we will handle copyright infringement claims for photographers that may not be very big, valuable claims, but we think it's important, to fight for them. Those claims may end up being like a 40, or if it goes to litigation, even 45%, just because, if the case ends up going all the way through trial, and Juliet, I think this, we took a case all the way through the US Supreme Court and won, and it's now going to go back and we're going to retry damages again. But in that case, after the first trial, we brought a motion for attorney's fees, and the court awarded us over $500,000 in fees on that case. Which isn't to say that every case justifies that level of fees, but federal litigation can be expensive. And so if an attorney is going to take a case on a contingency, there really has to be the upside. And if the upside is limited because you're talking about a photograph, a couple photographs that, don't necessarily have, the richest licensing history, and, it's everything isn't about making money, but it is a business, and we have to make sure that, that there's sufficient meat on the bones of a case to justify it. And so if there's a case where the value may be a little bit smaller, we may ask for a slightly higher contingency.
Did the court tell you, excuse me, the court know how much you wanted, or did they just come up with that amount? Like, do you say to them, this is how much time we spent, and then they do a calculation, or do they just think this is what we think it should be?
Yeah, not the topic of today's webinar at all, but if you've got a timely copyright registration and you prevail, you can seek your attorney's fees. When you seek your attorney's fees, you submit billing statements to the court to show all of the work, the time you've put in, the dates, the work, like what, and the court has a full and complete, catalog of the time put into the case. And then we'll go over that. The other side has a chance to object and say, oh, this is unreasonable, and this shouldn't have taken this long, or this wasn't, and the court will then look at it and say, no, this seems like an appropriate amount of time to have spent on it, and I'm going to award your fees. So, again, we don't have like and I'm speaking about just my firm in particular. Some firms might have just a one-size-fits-all fee structure. I don't think that's necessarily appropriate. I think that, there are cases where, we might take it on a, 1/3, if it goes to litigation, 40%. Sometimes we negotiate with clients that the case can settle before we have to file a complaint. It might be, 25%. It might be, 30% during the 35 and 45 that, when a complaint is filed, or then at some point, later on after discovery. So there's a lot of different ways to do it. The point, though, of a tiered structure is to basically tell the attorney, okay, the more time you put into the case, the more your percentage is going to go up to justify that additional time. Because, if I can settle a case before a lawsuit is filed by just sending a demand letter and negotiating something, why should I get the same percentage as if I have to go all the way through discovery and then settle it, on the courthouse steps before we go to trial, when I've now put in hundreds of thousands of dollars potentially of attorney time. So that's the point of that. Now, I told you there are 4 different structures, and we've talked about the first 2: hourly billing and contingency representation. Before I talk about the next 2, I want to kind of talk about the problems, the drawbacks, and concerns with hourly billing and contingency representation. With hourly billing, the attorneys have a disincentive to settle the case early. And this is especially, I find this all the time with defense counsel, where if a defense counsel, especially in a case that might have more value, the defense counsel says, well, before I agree to my client settling this case for 6 figures, I'm going to basically, I need to get my pound of flesh, because these firms live and die based on hourly billing. There are very few firms like ours that we have hourly billing cases, but it's a minority of what we do. And quite frankly, I hate hourly billing. I hate having to keep track of every, 0.1, every, 10th of an hour and, bill all my time. But there are firms that live and die, and the amount of the attorney's bonuses and salary, whether you make a partner, is all based on how much you bill. And if you're actually interested in efficient litigation and getting, settling cases where there's no evident defense, early to save your client money, you can see how that might be frowned upon by the partners of the firm who are depending on you to hit your billable hours for the year. So that's sort of the problem with hourly billing. The problem with contingency representation is, again, you really have to make sure that the attorney that you're hiring isn't just looking out for their own interests. Because if I've got a case that I think is worth $100,000, but I can settle it on a letter for $30,000. If I put a couple hours in, settle a case for $30,000, I make $10,000, it's a lot better for me than if I put $100,000 of attorney's fees into a case and then settle it for $100,000 and then get my percentage. I don't make anything close to my hourly then, even though that's what's in the best interest of the client. So with that said, the tiered structure does a little bit to address that, but it still, I think you can still see what the issue is. With that said, the third structure is a hybrid. And we don't do hybrids as often as I'd like to, because quite frankly, a lot of clients simply, especially a lot of photographers still can't afford to pay even a reduced hourly. But let's, if you could do 50% of my hourly rate and 50% of normal contingency, so half of it, like now the client has skin in the game and isn't going to push forward litigation that isn't worth it, right? And by isn't worth it, what I mean is that if it's not worth it for the client to pay $100,000 to an attorney to litigate a case, because the case is only worth $50,000, then it's probably not worth it for the attorney to handle that case. And that's why there's so few firms that are willing to take these cases on a contingency basis unless they're really valuable. Our firm is kind of the exception because we've gotten really excellent results even in smaller cases where, by pushing for statutory damages, by seeking attorney's fees, and, we handle enough of them that in the end, it all sort of works out for us. But it really, if it's not your business model, if you're a firm and this isn't your business model, like there's risk in doing this. The hybrid agreement, where it works, I think it really works because it tells the client, you don't need to settle now. If you have an opportunity to settle, you don't need to settle, but it's going to cost you, money moving forward, although less so than if it were just hourly. And for the attorney's perspective, it's like if the attorney has an incentive to settle the case at the earliest opportunity that they can get a good result, because they're still going to recover, a good chunk on the contingency side. So the hybrid is the third option. The fourth option is just flat rate. And flat rate fees, they're not used nearly enough. Our firm has done flat rate billing not only for, for parties who, flat rate billing tends to work better for defendants than for plaintiffs, but we've used it for both. We've had situations where someone filed a copyright infringement lawsuit against our client owned the copyright, hadn't copied, and basically was being accused of, it was really a bogus claim. And I looked at the complaints and I said, I think I can get this complaint knocked out on a motion to dismiss. And I ended up giving, the client had been told by another attorney that this case was going to cost them, there's no way they were going to get this case for less than $60,000. We gave the client a flat fee price of $15,000 to file a motion to dismiss based on the pleadings. And if we couldn't win, then we'd go to hourly, but if we could win, then that was it. And the client was like, great. We filed the motion, we won, and that was it for the case. We've had other situations where the client said, well, I got this letter, I need this dealt with, and we'll do a flat fee basis. And what I like about that is then the client doesn't worry about picking up the phone every time they pick up the phone to ask you a question, like, you're on the clock. And I think it creates a much nicer relationship where the attorney knows that they're going to get paid a reasonable amount for the work they're doing. If it's something that the attorney has expertise in and has done a bunch of times before, there's no reason the attorney shouldn't be, well, I shouldn't say that. In a lot of cases, there's no reason why the attorney shouldn't be able to, have a reasonable estimate of what it's likely to cost, or how many hours it's going to take, and then you can kind of make an estimate and go from there.
And with the contingency way of doing it, are they paying for any of the expenses, or is everything usually included in that contingency?
Yeah, so sometimes they are. We have cases especially for businesses on contingency, where the businesses pay the costs upfront. Mm-hmm. In other cases, the attorneys will advance the costs, but ultimately the client is always responsible for the costs. A lot of times, attorneys will have contingency agreements that say it's basically non-recourse, which means that if the attorney loses, they won't go after and they advance the costs and they lose, they won't go after the clients for those costs. But as a general rule, the clients are responsible for the costs. This tends to surprise some folks. And the way that I put it, just sort of to explain it, is if you were paying me hourly, you'd be paying my hourly rate plus you get a billing statement for my hourly rate plus any expenses that have been incurred and during that period, and then you're going to get a bill and you're going to pay for that. The contingency fee, and the keyword is fee, means that instead of my hourly fees, the fee is going to be based on the results. But those fees are still separate from the costs that are incurred in the case. And then those costs are separately recoverable, and the fees are usually based on the net recovery, on the gross recovery, not the net recovery after costs. And that's just also something to be aware of is, if I end up taking 5 depositions in a case, and the cost of a deposition, sometimes a little more than 1,000, sometimes a little less than 1,000, but $1,000 for actual court report or hard costs for a deposition, not unreasonable. If I end up taking 5 depositions, that means that I did a lot more work than if I didn't take those 5 depositions. Just think about how bizarre, how almost like obscene it is that an attorney's fee would be reduced because if it's net of costs, then I'm going to make a lower fee after those $5,000 in costs for doing more work. So the percentage is generally based on the gross, not the net. So these are things just again to be clear about.
I'm just kind of curious on one thing. For many of us, going to an attorney is like going to an auto mechanic, and it's frightening. We have no idea what it's going to cost, how many they're going to say it's going to cost, this part and the hours and stuff like that. Are there any red flags we should look at? And like, how do we go in and even know what it should cost ballpark? And are there red flags for us? And what do we look for as a client to protect ourselves?
Yeah. So that's a great question, Travis. And I wish that I had a very clear, simple answer for you. I don't, just because there really are different types of retainer agreements and how they bill is going to be different. There's also, as I said before, cases where we're just not going to take the case for less than 40% because even at that, it's probably not really worth our time. Whereas there might be other cases that are at a lower percentage. the key, I think, is, there's a topic that Juliet put in about how to manage your expectations and fees. And, my point on this, and sort of really in response to your question, is clear communication is critical. A clear retainer agreement is critical. Clear language in both your communications with the attorney and the retainer agreement are critical. And if an attorney is giving you something, and this is like my rule just in general, if an attorney is giving you something for your contract and you read it and you don't understand what it says, have real concerns about that attorney. As someone who's been practicing law for, well, a long time, I graduated law school in '95. There's something that I really realized, which is that a lot of attorneys think that if they're not using language that's convoluted and legalese, that somehow they're not doing a good job. And all the best attorneys that I know speak in plain language, speak in plain English, and really try to make sure that people understand, about the law, about the structure. And not doing that is really just a recipe for disaster. So, make sure that your communications with the attorney are clear. Make sure that you understand, and don't hesitate to ask questions. And if you're not getting satisfactory answers, that's probably your answer. All right. So I think we talked about what it is to hire based on a contingency. Let's talk about, what if you lose your case? Know the risk factors to consider. And one of those risk factors is always the costs. Another risk factor really depends on the nature of the case. In the US legal system, the presumption is that each party is going to incur their own attorney's fees. But under what's called the American rule, each party bears its own attorney's fees, unless there's either a statute that authorizes fee shifting, or there's a contract that authorizes fee shifting. So if you're suing under a contract and there's an attorney fee provision, you always have to really be aware of, okay, if I lose, what's my potential downside? If you're suing based on a copyright and you don't have a timely registration, you can't seek attorney's fees if you don't have a timely registration, but the other side can, right? This is one of the things, like, generally speaking, I'm a huge fan of the Copyright Act, and I think that it does a great job, big picture, in advancing copyright law and protecting copyright holders. But this is a really big but. Under the language of the Act, the prevailing party is entitled to recover attorney's fees. However, in order for a copyright claimant to be able to seek those fees, they have to have a copyright registration that is timely, which generally means predates the infringement. If they don't, then they can't seek fees, but a prevailing defendant still can. And this is one of the things that as an attorney, I have to be really, really clear with my clients about. And you want to make sure that any attorney you go to is really being clear with you about, the risk factors. If you're going to pursue a claim where you don't have timely registration, and even though maybe you're a photographer that has a really excellent licensing history for the work at issue, maybe your licensing fees are $20,000, $30,000, $50,000. Maybe it's a bunch of works and you think that you can make a colorable claim for $100,000. Okay, great. If you win, you could win $100,000. You're not paying attorney's fees on top of that because you don't have time registration. If you lose, if the other side establishes fair use, or somehow they had a license, or any other defense that they prevail on, they can recover their attorney's fees. And if your upside is $100,000, but your downside is many hundreds of thousands of dollars in legal fees that the other side could seek from you, you have to go into that with your eyes open And sometimes it doesn't make sense to do it, even though you've been wronged, even though it's your copyright. And again, if you do go into it, you got to make sure you do it with your eyes, with your eyes open. And there's one other thing that I think is really important for people to realize about if they lose a case. Let's assume that you obtained the rights to your work from someone else. Let's say you weren't the original, photographer, or you weren't the original, you weren't the creator of it, but the rights got assigned to you. And you go to trial, and you need to show both that the work was original and that it was proper, the rights were properly transferred to you. Let's assume, for the sake of argument, that one of your key witnesses ends up, getting trapped outside the country because they miss a flight back, or something happens when the case goes to trial, and you can't put on that evidence, and you end up, the jury says, well, you didn't establish that you own a valid copyright, and they find against you. There's a legal doctrine called collateral estoppel, which collateral meaning, you can picture like in war, like collateral damage, like there's the trial, but then there's things that are collateral to the trial. And estoppel means that you're stopped. So you're stopped in other collateral matters from asserting your ownership of the copyright if, in the first case, you had a full and fair opportunity to establish that, and there's a finding against you, you could lose your rights. And this is something that a lot of people don't realize, that if they lose, if there's a finding against them on something like ownership of the copyright, that could prevent them from ever being able to enforce those rights again, because they would be collaterally stopped from claiming that they own the copyright when there's been a finding against them in a prior case. And that's really important. It's really important. And it's something that, we regularly need to advise, well, not regularly, but, certainly at times need to advise our clients that is a real risk of proceeding forward if there's a possibility that, the evidence may go against them. In most cases for APA members, it's not going to be the case, because APA members are just going to be looking to enforce their rights in photographs they've taken, and there you go. So, all right. How are we doing? We're at 2:40. Let's get into some of the questions to ask before starting the clock. And some of these I touched on a bit earlier, like what other areas of law does the attorney practice? What are their primary areas? You want to ask about their experience. You want to ask about the results they've obtained, and you want to ask about who else they've represented. There's a visual arts. There's a group of there's a coalition of visual arts groups that Juliet and I get to participate in, and we do some really good work. And there's at least one person, in that coalition who purports to be advocating on behalf of artist groups, but represents infringers all the time. And the concern is, she's coming, this person is coming from a particular perspective, and you want to make sure that when you're getting advice, and when the attorney is advocating, for you, that they're not advocating a position that another one of their clients might take issue with, or there might be a conflict with positions that they're advocating in other cases for other clients. So that's really important. There's direct conflict of interest, and then there's sort of like the indirect conflict of interest. And you really, really, really want to know who is this person I'm speaking with? Who do they represent? What's their philosophy? Where is their bread buttered? And how does that fit in with them representing me in my case and my interests? You want to ask the attorneys if they'll be personally involved in handling the case. Some attorneys are, sign things up and then pass it on to paralegals or law clerks or case managers, and have very, very little involvement. And you want to make sure that, that the attorney that you're entrusting with your case is going to be handling it. Ask the attorney if they'll take the case all the way through trial if necessary. And earlier I mentioned asking about the results they've obtained. If it is a litigation case, Have they taken cases to trial before? There was an article years back titled "The Disappearing Trial Lawyer," and it was basically this like statistical article about how every year there's a whole new crop of students, and you look at how many attorneys there are now versus 10 years ago versus 20 years ago versus 30 years ago, and the number of jury trials hasn't gone up the way that the number of attorneys has. And so what that tells us is that fewer and fewer attorneys are actually getting trial experience. Or if it's not litigation, if you need, a work for hire agreement, or you need something else, how many times have they done that before? You want a really important thing to ask your attorney, and I can't stress this enough, is in your clear communication with the attorney that we talked about earlier, you also want to make sure the attorney understands what your goals are and what your expectations are. And then you want to ask that attorney, are my goals reasonable? Right? There's certain things that are allowable under the law, certain things that you can seek damages on under the law, and there's certain things you can't. And one of the things you can't is, for example, damages that are speculative, that you can't reasonably assess with any certainty. It's possible that my whole business is never going to recover and never be the same again, and it may well end up being just fine, and we don't know. If you think that the case should settle for $1 million because your business is never going to be the same again, and it's not something that you can prove without, or even argue without real speculation, an attorney should tell you that. Okay, the job of an attorney is to say, look, under the law, this is what's recoverable, and make sure that you're not laboring under a mistaken assumption. Or, if you're really clear that something are your damages, that you're not going to settle for less than a certain amount, and the attorney says, I don't think that's reasonable, it doesn't mean the attorney's right. And maybe it means you need to go look for someone else. But you want to make sure that the attorney is in line with you, that your goals are reasonable.
Is there a place where you can look up the history of attorneys, or how would you know, besides what they tell you, what their actual history in the court is?
So you can certainly ask for, like, if someone wants to know about cases that we've been involved in, we've got, the verdict sheets, we've got, it's a matter of public record.
Wait, what do you call those sheets?
Like verdict, like every time we take a case to trial, the jury returns a verdict form signed by the presiding juror, and we've got the court enters judgment on it. There's certainly objective records that back, should be able to back up what an attorney says. And this sort of goes to another thing that I was going to mention, which is just don't be afraid to Google your attorneys. There is one, very prolific New York attorney that went out there and talked a big game to a lot of photographers and filed more copyright infringement lawsuits than, he and his firm knew what to do with, and ended up getting his license to practice revoked. But before that happened, there were numerous, court rulings against that person. There were numerous findings of malfeasance, numerous claims from other clients about misappropriating funds, about making decisions without consulting with the clients, about all sorts of things that, and anyone that actually Googled and looked to see what was out there would have found these things. But, so don't be afraid to do a little bit of legwork. Another question to ask your attorneys is what is their representation style and what's their philosophy? Right? There are, I know attorneys that are very kind of conciliatory and try to be deal makers. I know attorneys who have a reputation of just being pit bulls, but not just pit bulls, people who are just downright assholes, and they think that serves them the best, and that's what that's what's going to get the best results. And when you ask what's your representation style or philosophy, not just with opposing counsel, but even with clients, there's some attorneys that are look, pass the case over to me. I'm the attorney. I know the law. Go away. And then there's attorneys who are much more like, all right, listen, we're going to do this together. And, I expect your involvement. I expect your input. The decisions are ultimately yours. And I think the best attorneys are somewhere in between those two, because really the client is going to the attorney for the attorney's knowledge and skill and sort of direction. But at the end of the day, it's the client's case, and the client really is the ultimate decision maker. So,
do you think that photographers can save money by doing the work ahead and just having it reviewed, like putting together the contract? This is what I think the contract should say, rather than having the lawyer write it? Or what do you find the best?
Yeah. So we do that all the time. Like I find that it costs the client the least amount of money and gets the client the best result if the client takes a first stab at drafting something, because the terms in that agreement, unless it really is something that's boilerplate, the client is going to have preferences on what the terms are. The client is going to have preferences over like what period of time payment should be made. What, if it's something where there's a license to use their work, for example, and they're like, well, I'm agreeable to it being used here, here, and here, but not here and here. I can't know that without going back to the client, right? And getting that information from the client. So either the client is going to pay me to get the information to the client, or the client is going to put a little bit of legwork in up front and give me something that might need to be put into a clear language and organization and whatever, but has what the client wants in it. And then I can work with that much more easily and much more quickly.
And if a photographer is working with an attorney, let's say it was one of those problematic attorneys, and that attorney's already put in the case, but then they realize there's a problem, can the photographer get out of it? How do they get out of it? Are they now suing their attorney? I mean, what happens there? Because that could be really intimidating.
Yeah. So the thing for clients to understand is that the clients are always the boss. It's the client's case. The client has the right to hire an attorney. The client has the right to fire an attorney. The client has the right to replace an attorney. The client, in certain instances, the client has a right to also retain co-counsel. So if it's a contract matter and you have an attorney do a first draft of something, but you're not communicating well with the attorney, you can always take that draft. It's yours. You pay the attorney to put it together, to do his revisions. You can take that to another attorney and say, hey, can we take a look at this? If it's a litigation matter and you decide you want to change counsel, great. If you decide you want to bring in co-counsel, great. Just in the last week, literally from the last 7 days, I had one client reach out to us, not happy with his current counsel because the current counsel is, this is similar to what we discussed earlier, works for a firm that is primarily an hourly billing firm. They took a case on a contingency. The case seems to have significant value, but they're not willing. They figured they were just going to be able to settle the case quickly, and now that it might be going to trial, they're like, well, the partners, and they don't want to take it to trial. They're trying to get the client to settle for less than the client wants to settle for, and I'm like, we'll take it to trial. And I had another client in another case that said, hey, I hired this other attorney and he's just a little bit like he's overwhelmed and we need that. I want to bring you on as co-counsel. And we're in a conversation about coming on as co-counsel. So those are two things that clients can do.
But if the other firm was taking it on a contingency and now they're not going to get to settle it, what do they owe that firm? Because they weren't paying them an hourly rate, they were paying them on contingency.
The general rules in that situation are that the firm has a lien that only applies to the recovery on those claims. So because the firm took it on a contingency, if there's no recovery on those claims, then the client doesn't owe the firm anything. If the client does get a recovery on those claims, then the firm has a lien for the reasonable value of their fees. And the way there's a bit of authorities kind of a little all over there on how that's decided. But in most cases, what you're going to do is you're going to look at, okay, what's the value that the new firm brought in? What's the value the old firm, brought in? Sometimes that's simply, you just look at the hours they put in. Other time, but the court has the discretion to say, yeah, but those hours didn't really lead to the value of the settlement. These hours did, and trial counsel, so you figure that out. But and then at some point, the courts will do rough justice if it has to go to the courts, if the parties can't agree, and say, all right, X percent of the fees, and the fees should be the same, right? If the fees are 40%, let's just assume, like for the sake of argument, the fees are 40%, and the case settles for $300,000, that's $120,000 in fees. That should then be, instead of that all going to the new attorney who came in because he didn't handle the case from day one, that would get divided in a way that's either agreed to or adjudicated through arbitration if it needs to be between the new attorney and the old attorney.
I think we have a new series. It's going to be called Rough Justice.
I got one question for you. You gave us such great questions on what we should be asking a lawyer when we're first sitting down with them. On the flip side, what is the best way for us to prepare, basically prepare ourselves going in on the first consultation of the questions you would ask us so we would know what to bring in and what to answer. So we're maximizing that first consultation for success and for the information that you would need from us.
Yeah, thanks, Travis. And I hate to keep answering your questions with, I don't have a great answer to that, but because there's so many different things that a client could come to me about, what I would ask the client really is going to depend on what those things are. If it's a copyright claim, I want to, I want to know, is the work registered? Is it, who have you licensed it to? What's your licensing history? Like what's the value of this claim separate from statutory damages? And then are there statutory damages available? Is there willfulness? Like there's a bunch of questions I want to know for that. If it's something else, if it's a, if it's a license agreement or some other contractual arrangement, I want to know, is this something you've done before with other clients? Let me see your current agreement. How does that serve you? How does it not serve you? What changes are you looking to make to it? Is there anything specific about this transaction? But the one thing, this one sort of overarching question is, I always want to know what my client's expectations are. The same way that I said that a client should be clear with their expectations with the attorney and ask if those are reasonable, I want to know what my client's expectations are. Because I could think, oh, this is a great case. And it has limited value, but this is a great case. I can get a good result for the client and great. But if the client says, no, Steve, you think this case is worth $50,000, but I'm not going to sell it for less than $500,000. I'm going to say, I don't think I can help you in this one. And I literally had that. I mean, again, even like in the last week or two, I had a call with the client, and the client said, had another attorney and was looking to move from another attorney, and told me, like, I think this case should be, he's like, I want someone that can help me get $2 billion on this case. And I was like, I'm not sure I'm the guy. The worst thing ever is, for me as an attorney, is when I know that I can get a good result for the client, but the client has unreasonable expectations. And part of that is my responsibility to be able to convey to the client, like, what the laws, what the limitations on what they can recover are, et cetera. But there are people that just don't listen, that are just like, well, no, then I'm not going to settle for that. Or so, I think one of the most important things when you're speaking to an attorney, if you're speaking with someone that really knows what they're doing, or at least has a good reputation, because I know as a layperson, you may not know, be able to independently judge if they know what they're doing. But, it may sound like a contradiction, but I want a client that has a very clear sense of what they want and what they're fighting for, but also knows to, when to take advice and listen to their attorney and be flexible.
Thank you. Are there other questions? Does anybody else want to ask something? Feel free to jump in. Otherwise, continue, Stephen.
Oh, let me just add two other things that I forgot that I didn't mention before, which is, if you're really having trouble with your attorney, there are two other things that you can do. One, especially in state court, is if you bring a lawsuit, you're also, you're the master of that lawsuit. You can tell the attorney, dismiss the case. Just dismiss the case. I don't want to, I'm not going to push forward with you anymore. And you've got the ability to do that. The other thing you can do is you can speak directly to the other side. And sometimes as an attorney, I encourage my client to do that. Because attorneys, there are times that I think that the other attorney is the problem. That the other attorney is giving their client bad advice. The other attorney is not appropriately conveying my client's position and concerns. And it may be best for the parties to just talk and see what they can do. Right? My goal in litigation is not to litigate a case for myself. My goal is to reach a resolution that's satisfactory to my client while advising them of what's available under the law. Right? And sometimes the best thing you can do as a client, if you don't trust your attorney, but you've got a pretty clear sense of what you want and maybe how you might structure something for a settlement, talk to the other side. There's nothing stopping you from directly speaking with the other side. And just go around your attorney. I mean, ideally it's with your
a collaboration.
Yeah, no, I mean, ideally it's with your attorney's sort of blessing and suggestion and partnership. But Juliet, to your point, if you really are having a problem with your attorney and you don't know what to do, it's not like you can't go to the other side, try to work out a settlement to be like, hey, and then go to your attorney and be like, listen, I spoke to the other side. This is what we're going to do. Write it up.
Okay. Thank you. That was really helpful information. I feel like it's sometimes it feels a little mysterious out there until you hear. I mean, even just to feel like you have permission to ask questions, sometimes it seems rude to ask, tell me your history in this area. So thank you for that. I appreciate it. Well, we greatly appreciate this. It is going to be an ongoing series. We're going to be talking about other deeper dives into registering copyright, image licensing, A&I, sub-licensing, and such. So thank you, and we look forward to next month. And that's it.